Thank you very much. We are back in session. Our next case is Evans v. Da Silva, 2019 P288.
Good morning. May it please the Court, Richard Chambers on behalf of the appellant Brian Evans. As your honors are aware, this is a case that's kind of unusual, has a lot of issues. One of the main issues is whether or not the trial judge should have recused himself in the case.
Before we get there, counsel.
Yes, Your Honor.
If we could go back perhaps a few chapters. Where in the record is there evidence that Mr. Evans was the sole beneficiary?
I don't know if there's evidence in the record per se, Judge, other than he's the only plaintiff. And there is not evidence that he's the sole beneficiary.
Okay. So you would agree with me, wouldn't you, counsel, that cases from our court indicate that given the short time structure in which an administrator or executor has to file an appeal, that's even if we ignore from 2018 a lack of appeal, but that they can do so long as an attorney of law promptly comes into the case and represents the interests here. And in this case, it was close to 2 years, wasn't it?
Part of the issue may have been the pandemic, Your Honor, for the delay. Another issue.
Well, with the pandemic, the attorneys were still out there, right?
Yes, Your Honor.
In practicing law, but...
Well, another issue would be when Mr. Evans discovered the main issue with respect to the judge.
Even if we allowed him to file this appeal pro se, given the case law, how do we allow it to go any further when for practically 2 years, in essence, he was practicing law and you stepped in just, again, shy of 2 years after he filed the appeal?
Well, I would say I make an argument in my brief that he wasn't practicing law with respect to this court because he had filed, put the court on notice of his appeal, and then he did hire an attorney. There was an issue where he was waiting for the transcripts. He didn't get the transcripts for a while, so he didn't have the transcripts to hire an attorney. When he finally did get the transcripts, he did seek legal counsel to pursue the appeal. He didn't practice law with respect to the brief or coming before this court. My argument was he simply filed a notice of appeal.
Right, and almost 2 years passed before you filed your appearance, correct?
Yes, and I would say he had he was living in Hawaii. He had an issue with getting the whole. It was a lengthy trial, and it took him a while to get the transcripts.
Counsel, on a related note, how is the recusal issue even properly before us, where I take it there was no appeal of the denial of motion filed years after the judgment?
I would submit, Judge, that it may have been preserved in a lower court when he raised that issue before the trial judge, and the trial judge went on record and actually confirmed it. And with respect to that, I would say it was preserved.
Well, except, I mean, there was a ruling on the motion,
yes, Your
which
Honor,
occurred years after the judgment. And if I'm understanding the record accurately, there was no appeal taken of the denial of the motion. So again, how is the issue even properly before us?
I recall when I was looking at what Mr. Evans had filed before the appeals court, there was an indication in the record that, you know, he had so much time to get the transcript and then he had so much time to hire counsel. So with respect to preserving the issue, I would just say, he wasn't practicing law, but it was brought forth.
But I'm not talking about the representation issue now. I'm talking about there was no notice of appeal taken of the denial of the motion to recuse.
I would say that the opposing counsel, the appellee, was put on notice, the way he raised it in the lower court and in the way he brought it up to this court.
Counsel, though Rule 4 is clear, he had 30 days. It's an incredibly short period of time that you have 30 days to protect and preserve an appeal. And unless we're reading the record improperly, and I'm happy to hear from you why we are, I don't see at all where that 30 days, that time period, was at all honored.
I would just step back to where, at that point, I agree he did not have counsel. He was pro se. And I would just say that an issue of this magnitude, that traditionally the appeals court would not want to dismiss this on a technicality.
So when you argue, though, that he attempted to appeal the issue in this court, I think that's what you wrote in your brief, and then the appellees opposed that appeal, can you give us some docket numbers or anything to trace this map?
I'm sorry, Your Honor, I couldn't hear you.
Could you give us some docket numbers or some pointer rather than just leaving us to figure this out?
I'm only referring to the docket number of the lower court.
Yeah. But you say he attempted to appeal the issue. I don't know what that means. If it's not an actual notice of appeal, what does that mean?
So the lower, I believe the docket of, I have the docket of this court, Judge. I'm not sure if I have the lower court docket in front of me.
Well, you say that some court ordered Evans to argue the issue in his full appeal. Do you know, was that the trial court or was that us?
I thought that within the docket of the appeals court, he was given leave to bring it up because the appellee had filed an opposition to it, raising that issue.
That was a single justice appeal.
Yes, Your Honor.
That's what it was. And so the issue before the court is whether the defendant could act as his own attorney, being an administrator or an executor of an estate. And they preserved the issue, said, we'll give you the opportunity here to argue that issue. So that before we get to the substantive issues, first of all, we have a September 17, 2018 verdict, a September 21st, 2020, first time judicial bias is ever raised. I mean, we're not talking maybe 60 days or 90 days or whatever after even a motion for a new trial.
Yes, Your Honor, and thank you for that question. And how I would answer that is, one of my arguments is that, the trial judge had a duty sua sponte to raise that issue on his own. And failing to do that, it wasn't up to the defense counsel or plaintiff's counsel or even the plaintiff to be a police officer, and try to figure that out. But what I'd like you to consider is the fact that when he found out, it's the look. I'm not arguing bias to him during the trial, but what I'm arguing is the appearance of impartiality or impropriety after the trial was over to learn that information, even though it was 2 years later.
Just so that the record is clear, that the judge's wife had admitting privileges at the hospital.
Yes, Your Honor. Yep. And I think that to the average person on the street, I got a ride to the court this morning, and the driver asked me, where are you going? I said, the appeals court. What's the issue? I raised the issue, and it raises an eyebrow. To the average person on the street, when they hear the trial judge on a medical malpractice case is married to a doctor that had admitting privileges, it does raise an eyebrow to the average person.
Counsel, I may be thick, but what help me out to understand what admitting privileges means.
Well, I don't know, Your Honor, and that's the problem. I don't know what that means. I don't know whether that means she had the ability to perform surgeries at that hospital, or she had in the past, or she had some kind of financial arrangement. I don't know. And that's one of the problems that the average person on the street would have, just simply hearing the judge is married to a doctor. And I just wanted to submit to Your Honors, and I know you're worried about the technical reasons for getting before you, but I just want you to consider the fact that, maybe the better practice would have been for the judge to just simply say, look, I want to put it out there. It's a medical malpractice. It's a wrongful death. I'm married to a doctor. And then give both sides equal opportunity to then decide whether they want to recuse him or not. And I just want to put that out there.
Well, but counsel, is there any reason why? I understand he's disgruntled, and he's disgruntled for a long period of time, maybe forever. But we do try to keep things decided in a timely and orderly way. Is there any reason he couldn't have discovered this in the 30 days or within a year of the decision?
Well, I don't know, Your Honor. I don't know whether the information 2 years later was readily accessible on a Google search, or that's how he found it, and it wasn't prior to that. That I can't answer, why he didn't discover it earlier. But the fact remains that he did discover it. And, yes, he's looking back and he's saying, well, I lost the trial. We had some adverse rulings, and one that I bring out is about the juror. And again, I'm not trying to say that there was judicial bias per se, but I'm just saying it's the look of impartiality that isn't there anymore. If Your Honors, did you have any other questions about any other issues?
Do you want to turn to the other issue in the case?
The only other issue that I'd like to raise, if you allow us to get there, would be during the trial, a juror does come forward. This was a case where Mr. Evans' mother passed away, and there was expert testimony that from both sides with respect to the reasons. And one of the reasons of death was it was argued by the plaintiff's expert that his mother had sleep.
Counsel, we have read the brief,
okay.
So we understand the factual argument. As I recall the record, though, there was no objection raised.
Thank you, Judge. And I'd like to say my reading of the transcript is there was an objection raised because plaintiff's trial attorney did say, we don't want this person, or along those words.
So they said, I don't think this juror should serve,
yes,
something like that. You think that's sufficient to alert the judge there's an objection?
I do, because in the midst of trial, this jury took it upon themselves to come to the judge to make the information that the juror had and whether or not it was going to be shared with the other jurors. And I think stating that is enough, because I think he goes on later to say something about a little more too about we would ask for an instruction if your honor is inclined to keep him.
Again, we're going to go back over 2 years to an event when Rule 4 requires an appeal on those issues to be 30 days. Why?
My only argument would be, Your Honor, that Mr. Evans did have trial counsel. He felt abandoned by trial counsel. He felt that he needed to pursue the appeal himself. Obviously, I'm not holding him a stand of attorney, but my argument was that he was confident enough to raise the issue, even though it was later on, and file a notice of appeal. And I understand the issue with the time that's gone by. And again, my only argument there is that I would hope the court would want to not dismiss this. He was representing himself pro se and on a technical issue.
Thank you very much,
Your
counsel.
Honor.
Okay, I understand the appellees are splitting their time. I have the reverse order, but it looks like Attorney Botros is arguing first, and I have you 2 minutes.
Attorney Knight, Your Honor.
I'm sorry.
Lydia Knight.
Oh, I'm sorry. I have the wrong page. Sorry.
Thank you, Your Honor.
Very much. And you're taking 5 minutes, I
Yes, Your Honor.
Thank you very much.
If that much time, I will try and keep it brief. Good morning, Your Honor. May it please the Court. Lydia Knight on behalf of Dr. Ronald Marvin and Orthopedics Northeast, PC, the appellees. As the Court is aware, I will only be taking 5 minutes of your time. I plan to address 2 issues on behalf of all of the appellees, and the following Attorney Brouillard, will address the remaining issues, including the recusal issues. I will be addressing the issue as to juror number 27, as well as the capacity issue.
Could you start by addressing why isn't your brother right that the statement made that this, to the effect that this juror shouldn't be seated, was enough to preserve the issue?
Yes, Your Honor. It is not enough to preserve the issue for appeal. All attorneys know that you have to object and state the grounds for those objections. That was not done here. What was said was, you know, if you're inclined to keeping him, I would want an instruction that he can't go in and talk about that. I think he should be let go. Under the statute, Mass General Laws 234A, Section 74, an objection must be made as soon as possible regarding a juror after its discovery. In the case of Commonwealth v. Parham, the Court noted that exceptions no longer need be taken, but that a party is required to object and to make known to the Court the action which he wants taken. Here, that was not done. There was no objection stated, and there was no grounds for the objection stated to the juror. And I think you'll also see that in the Commonwealth v. Perryman, where an objection also was not preserved, even though the attorney did object to the use of, in that case, it was the use of some evidence. The attorney did object to it, but on only one ground, and then later objected once that evidence had been, it was a demonstrative evidence of the use of a telescope. The Court said that objection was too late and was not preserved for the appeal. So for those reasons, I would say that the plaintiff, first of all, has not cited any case law where that would be noted to be an objection, saying, I think he should be let go. And I would suggest to the Court that if the Court starts to take those sorts of statements as objections, that we would be in a whole other world trying to decipher what an objection is and what it isn't. Attorneys know that when you're objecting, you have to state an objection and the grounds for it in order to preserve it for appeal. And again, that just wasn't done here. I'd also like to state that with respect to the juror, the appellant has not demonstrated that there was a substantial risk of extraneous issues being injected into the deliberations. Here, the juror comes forward stating that he's aware that a heart attack can happen out of nowhere. That's not even an issue that was contentious in the case. The 2 experts, and I appreciate that the Court has read the briefs, but the 2 experts state that, you know, either Ms. Bousquet passed away from a hypercapnic respiratory distress issue or a primary cardiac event, which was most likely an arrhythmia. The judge even said in his instruction that there was no issue as to whether or not a heart attack can occur out of nowhere. So the fact that this juror had this information, which I would suggest to the Court actually isn't extraneous information, and it is more common sense and life experience, which jurors are entitled to bring into the deliberations, that for those reasons this is not an extraneous issue, and again, that it was not objected to. So could this juror inject that into the possibilities in the deliberation?
I believe that the juror certainly could have and would be entitled to, and that the instructions given to the jury, again, which were not objected to and I would suggest are completely appropriate under the case law, that the juror may bring in their life experiences and their common sense into the deliberations, and that was completely appropriate if that juror did do that. But again, there's no evidence that would be done.
I'm confused. I thought there were some instructions that the judge asked the juror if he could exclude or she.
So, Your Honor, when the juror brought the information to the judge, I believe it was on day 3 of the trial, at that time the judge asked that the juror not discuss his medical conditions, and I could find the page for you if I had a minute. But he did give some instruction stating that the juror should not put his experience aside, that he should put his experience aside and listen to all the testimony and not formulate any decisions until such time as the evidence was in and he began to deliberate with his fellow jurors. There was no further specific instruction given to that juror. Rather, at the end of the case, the jury instructions were given, which were that the jurors could rely on, and again, I could find the page if I had a moment, but that they were able to rely on their common sense experience and any expertise that they may have on a given subject. And you'll see that in the Holleran case as well as the Blank case.
Okay. Counsel, I'm afraid your 5 minutes is up.
Thank you, Your Honor.
Hear from your brother.
Good morning, Your Honors. My name is Chad Briard from Foster & Eldridge, and I represent Emery Mead, RN, Kristen Silva, RN, Holy Family Hospital. I should also point out that we did represent 2 of the steward entities, but pre-trial, by voluntary agreement, they were dismissed from the case. So really, I'm focusing on those 3. So I'm here to argue, to pick up on the refusal issue. I think Your Honors have already pointed out that I don't believe the appeal was perfected and why, and that's not demonstrated in the docket anywhere. But also there's a huge timing issue here. And, really we need to call this appeal what it is. It's a last-ditch attempt to overturn an adverse judgment over 2 years after the fact. And this is exactly the type of case that is warned about in the Demoulas matter that we cite to, when it said, look, you've got to present pretty strong evidence as to why you waited this long on this evidence. And really the issue in this case is all about something that is listed on the Board of Registration in Medicine in the Commonwealth's website. This is not something that disappeared from Google overnight. This is just a listing that was on their website. So there's absolutely no reason why the plaintiff pro se or their trial counsel couldn't have brought this to the judge's attention earlier by motion if there was a real concern about it.
So does our concern, though, with the judge having a conflict of interest diminish because time had passed?
I'm sorry, Your Honor, I couldn't...
In terms of justice and the perception of the fairness of the system, does our concern diminish just because time has passed?
Well, I think it depends on the nature of the interest which is being brought forward as well. Here we're talking about a very attenuated connection, which is essentially admitting privileges to a hospital.
So I think I'm borrowing his question.
Oh, I'm sorry.
So what does that mean?
Well,
how do we know what it means? There was no factual findings here.
I'm sorry, Your Honor, I couldn't hear the last part of your question.
We have no factual finding. How do we know what admitting privileges mean, that it's some limited relationship?
Well, I think you have to rely on Judge Cabot, because he is the one who ruled on the motion, and he went through the Lena analysis, and he stated what the issue was. And he stated, previously, and not at the present when he was ruling on it, previously his wife had admitted privileges there. He explicitly ruled out that there was no employment connection between the hospital and his wife and didn't disclose any other financial interest. So I think the other thing that is also helpful, both counsel briefed this and looked at all cases involving interest and bias. There's not one case about admitting privileges to a hospital constitutes a direct financial interest that a judge has to come forward on.
Okay, but I hear all that, and I have no idea what admitting privileges means. But notwithstanding that, and putting aside all the potentially profound problems with the appeal, why isn't your brother correct that in an ideal world, at least, the judge should have disclosed to the parties that, oh, by the way, my wife has this particular relationship with the defendant, one of the defendants, and let the parties sort that out, whether or not that's a problem?
Well, the problem is when it's such a de minimis connection, I am sure that the trial judge was simply not aware of it. because...
Not aware that his wife had admitting privileges at a particular hospital?
Well, so I feel a little bit hamstrung here because I know what admitting privileges are, right? So admitting privileges, I'm happy to explain briefly what they are. Basically, it simply allows a physician to, if they have a patient, particularly, in this particular case, Dr. Tabbitt, according to the board profile, is family practice. She's a primary care provider, which is largely outpatient-based. If they have a patient who's having an emergency issue, they're allowed to admit that patient into a hospital for the patient's benefit. That's all it means on its face. Now, you can have admitting privileges and be a surgeon, and maybe you derive some business from that, but Judge Tabbitt, in his order and his explanation about his wife's privileges, said nothing about that. And really the test is it abuse of discretion on Judge Tabbitt's part in finding that he did not have to recuse himself and did not have to remand it for a further trial?
Do you think the concept of admitting privileges is so undisputed that we could take judicial notice of that? Were we to find a appropriate secondary source? I mean,
admitting privileges have been around for 100 years. So, yeah, you probably could take judicial notice of it. The only reference I could find relative to admitting privileges in any type of financial interest is from the IRS, who said just having admitting privileges alone doesn't qualify as a business use income. So, not to be cute, but if the IRS is not viewing just having the admitting privileges alone as income and not something that needs to be reported, I think that goes to the point of it's something you could comfortably take judicial notice of.
Okay, so if this is raised, had this been raised before trial, you're saying it was still within his discretion to say that he did not have a conflict?
Yeah, I believe so. I believe so based on the nature of the interest. I think that's true. I think he might, if he had it in his forethought, he may or may not have raised it to the part. This happens all the time during trial where judges raise things that are clearly not direct interest or conflict, but they raise it to raise it, right? I'm sure if he had in any way, shape, or form saw this coming, he would have raised it, and probably the parties would have had no problem with it. We typically don't at trial. So,
but both counsels are misstating the obligation of a judge. It isn't to put it out there to the attorneys and say, "You good with this?" That's not what is required of a judge. It's two steps. One, an internal analysis, and the second is the appearance issue.
Yes.
Neither of which makes, if the appearance is bad, it doesn't matter what two counsels say. That's good for us, Judge. You can stay on. If outwardly it looks as if there's some sort of influence, then the judge should recuse. So it's not about saying, in the ideal world, wouldn't it be nice for you to say, by the way, my wife works here or so-and-so, are you too good with it? That doesn't dissolve a judge of the obligation to recuse when appropriate. That the position that the judge had is that it was de minimis, that this is nothing to do with this case. And admitting privileges, which I would suggest judicial notice could be taken, is just that. I mean, if you went to the hospital in the emergency room having a difficulty breathing, they'd admit you. Just as if they would if a doctor said, admit so-and-so, right?
Right.
It's a really nice fancy word for not much.
These days, right? I mean, the system 100 years ago was different when you used to have PCPs who would come into your hospital. But that doesn't happen anymore. So it doesn't really mean much. I think you're right. I would say, though, Your Honor, just picking up on your last point, the real big point here is that, this court has to view this under an abuse of discretion standard. The fact that he went through the Lena analysis and he ordered and said, look, I looked internally and I didn't think there was a bias here, but also I took a step back and tried to look at this objectively, and I don't think there's an interest here that would have controlled this, even if in an appearance of impropriety standard. So, and there's just no showing from plaintiff's counsel that, why we should question Judge Tabbitt on that point, or how he abused his discretion. There's absolutely no showing for that. So,
do you agree that in the calculus, it's not whether people misunderstand what admitting privileges happen to be.
I'm sorry, Your Honor, I missed the first part of that.
So would you agree with me that it's irrelevant whether people are confused or not? The outward side kind of impression of is this improper or not has to be based upon what the judge knows is true.
Right. And so the second prong of Lena is, does the judge reasonably have a belief that it would be considered, raise the appearance of impropriety, right?
But
so,
isn't it possible that if the public were confused about this, there could be an appearance of impropriety, even if the judge, knowing what admitted privileges are, figured that no reasonable person could do that? I mean, couldn't there be a Lena problem on prong two, even if under the facts, it wasn't a big deal?
Well, look, Lena doesn't say, hey, let's submit this to a poll, Family Feud style, and find out what the public thinks about this issue. It puts a reasonable standard on the judge, what the judge knows about the interest, and assuming that whoever was educated about what this interest actually is, would it be considered an appearance of impropriety or not? There's absolutely no requirement that the judge externalize or try to find out what people on the street think about it, whether informed or uninformed.
Thank you very much, counsel.
Thank you.
Very interesting case.